They stood them all along this big hole and they shot them.
When the Queen came and visited for about 3 days, and a lot of children went missing there.
I said if I didn't have a tubal ligation, then I would never see my daughter Patricia again.
Hello, my name is Laurie O'Rourke, and I work with the International Tribunal into Crimes of Church and State, the ITCCS, a coalition of survivors of church violence in 9 countries which has helped to convene this online common law court of justice. The purpose of this court is to present and judge evidence of crimes against humanity by churches and government in an open online public forum. The court is established under the law of nations and common law, which require that citizens protect their liberties and communities themselves when governments, police, and courts refuse to do so. The consistent refusal of courts across the world to bring to trial those responsible for child trafficking, institutionalized rape, and genocide has compelled us to take this step. Our court consists of 5 sworn judges with legal backgrounds, an office of citizen prosecutors, and 58 sworn citizen jurors based in Canada, the United States, Ireland, England, Holland, Italy, and Australia. The specific mandate of our court is to consider and come to an enforceable verdict concerning evidence that chief officers of the Vatican and other churches, the Crown of England, and various governments are responsible for committing and or concealing deliberate acts of genocide and crimes against children. This evidence will be presented online, including YouTube broadcasts to allow the world to participate in this historic, citizen-based judicial process. There are 5 initial cases in the docket of our court involving crimes at Indian residential schools in Canada and within the Roman Catholic Church. The first case, covering the general evidence of genocide in these schools and adjoining Indian hospitals, will begin following this preamble, with an opening summary by our Citizen Prosecutor's Office. After that, a detailed presentation of evidence will be made by our prosecutors that will prove beyond any reasonable doubt that Canada and its churches are guilty of committing and concealing an ongoing genocide against Indigenous peoples. This online evidence is a precious historical resource and represents something new in the world. The first time that citizens themselves name and prosecute heads of state and churches for criminal actions. We urge you to be a part of this process by examining all of the material that we will be presenting over the course of the next several months and sharing in the verdict and the enforcement of the decisions of this common law court. Thank you.
May it please this court. The opening case in the docket is in one sense the most important and illustrative one that this court and its citizen jurors will hear, in that it addresses the essential matter of genocide by church and state, in a nation until now never acknowledged to have committed such crimes, namely Canada. This case will do so by revealing through documentation, eyewitness statements, and other evidence the existence of a deliberate, historic, and criminal plan across Canada by government, churches, and corporations to destroy entire non-Christian peoples under the guise of religion and education in order to seize their lands and resources. This case, in short, involves a homegrown Canadian genocide devised at the highest levels of church and state power as early as the year 1890 and implemented by 3 major Christian denominations, the Roman Catholic, Anglican Church of England, and United Church of Canada Presbyterian Methodist. Until today, it has been impossible to win a hearing for the evidence of this genocide in any court of law in Canada, since no court has allowed such a case to be brought before it, a fact that has compelled the formation of the citizen-based Court of Common Law. As early as the spring of 2000, Crown-established courts in Alberta and Nova Scotia ruled that they had not the jurisdictional competence nor the will to allow proceedings against the Crown and various churches regarding criminal acts by these agencies. These decisions were remarkable and inexplicable, considering that 2 years earlier, in the fall of 1998, the British Columbia Supreme Court under Justice Donald Brenner had firmly established that a federal plan to intern en masse and culturally exterminate Aboriginal children through Indian residential schools existed in Canada as early as the year 1910. Since these Canadian court rulings, neither the sponsoring churches that operated the residential schools nor any single individual has ever been brought to trial in Canada for the death of a child in these so-called schools, despite the documented fact that at least 50,000 children died in these facilities under the legal care of the Government of Canada and the Roman Catholic, Anglican, and United Church of Canada. Even more astounding is the fact that despite this evidence and the 1998 Brenner legal decision, during the years 2006 and 2007, these same churches and government arranged to absolve themselves legally of any liability for the deaths of these children and other residential school crimes. They did so by establishing an agreement of indemnification under which the churches that ran and administered these schools would not face criminal prosecution for the horror inflicted by these institutions in the residential schools. In return, they would publicly disclose certain aspects of the residential school operations, a disclosure, it must be noted, that has never occurred. In addition, in utter violation of judicial independence, the Canadian government has effectively annulled court decisions, like the Brenner case, regarding the joint liability of both church and state for these crimes, and assumed complete liability, including by shouldering the financial burden for compensating survivors. These facts, we will argue, constitute not simple negligence, but an enormous and deliberate miscarriage of justice, as well as an intentional concealment of the Church's primary responsibility for these crimes by the Canadian judiciary and their political sponsors. For that reason, these events also amount to an act of defrauding of the people of Canada by their own government. The details of this fraud will comprise much of the evidence in the second case before this court, which will address the efforts by the Canadian government and its churches to conceal and minimize their crimes in Indian residential schools through the means of a self-appointed, restricted, and legally incompetent body referred to as the Truth and Reconciliation Commission. Our first case in the court's docket, however, will focus on the facts and the details of the crimes these churches and government are so desperately trying to cover up. For the record, this opening case recognizes that the hidden truth of deliberate genocide in Canada only began to surface publicly in the year 1995 as the result of the events surrounding the firing of a West Coast United Church clergyman, Kevin Annett, who publicly exposed the first evidence of murder of an Aboriginal child, Maisie Shaw, in his church's Alberni Indian Residential School, and for revealing land theft by his church. Both of these issues will figure prominently in our case. Let us begin by saying that the crimes we will document to the court defy the imagination and all moral and rational explanation, especially since they were aimed at and committed on children. And these horrors were not committed exceptionally or randomly by isolated persons, but systematically and legally by competent officers of the state, churches, the police, and judiciary at every level of Canadian society for well over a century, with the complete sanction and oversight of all legal authorities in the Crown of England. These crimes fit every specific definition of genocide under international law and all 5 definitions of genocide listed in the United Nations Convention on Genocide, which was ratified by Canada in 1952 and given enabling power under Canadian law in the year 2000. This fact clearly allows Canada and its churches to be indicted under the laws of their own land for these crimes, even if Canadian courts refuse to do so. Thus, it is the argument of our prosecutor's office that the named defendants in this first case in the court's docket are guilty of the following 5 intentional acts with regard to the inmates in Canadian Indian residential schools and Indian hospitals. 1. Killing individuals in the targeted group, directly, indirectly, and by omission of action. 2. Preventing births and conception within the targeted group. 3. Inflicting bodily, emotional, and mental harm on the group and individual members. 4. Creating the conditions for the long-term destruction of the group, including by stripping them of their traditional lands, resources, and identity. And 5. Dislocating and moving members of the group to another group, and confining them in conditions of disease, starvation, and destruction which continue. In addition, we will argue, the defendants and their organizations are guilty of conducting a criminal conspiracy to seize the lands and resources of the targeted indigenous nations as part of their historical plan to exterminate these non-Christian nations and to conceal this conspiracy from posterity. It is a fact that the regime that caused these conditions and the consequential death of at least 50,000 children in the Indian residential schools was established in 1920 by a Canadian federal law. However, this legislation, while eventually authorized by the Parliament of Canada, was initiated through a secret order in council in Ottawa, that is, by a handful of civil servants under the express command of the Crown of England and its Privy Council office. This law required that every Indian child 7 years and older had to be forcibly incarcerated in internment camps, deceptively called Indian industrial schools, or their parents would go to jail. In practice, children as young as 3 and 4 years old were routinely stolen from their parents by either clergy or officers of the Royal Canadian Mounted Police and imprisoned in these camps, where half of them would die consistently throughout much of the 20th century. If these children ran away from their imprisonment and were caught, they were immediately branded as juvenile delinquents under Canadian law and could be imprisoned and punished as if they were adults. Any Canadian citizen could be deputized to hunt down runaway Native children, and under the terms of the Indian Act, quote, employ whatever force is required, unquote, to return the escaped children to the residential school. This was in effect a license to brutalize and even kill Indians who hid these runaway children or resisted their re-imprisonment. No matter how young they were, children who escaped and were returned to residential schools routinely faced prescribed floggings, rape, forced confinement for days, torture, and denial of food, all of which would often cause their death. It is important to note that these punishments were routinely prescribed according to a common policy emanating from the government, and were not the random acts of isolated staff members, as the defendants have claimed. The purpose of these prisons, called schools, was not to educate, but to eradicate a majority of Aboriginal children in a given area, and to enslave, brutalize, and recondition those who survived, destroy the fabric of Aboriginal families, and seize Indian lands and resources in the process. The constant and documented rate of mortality of between 40% and 60% in these schools in every region of Canada for at least 60 years, from 1891 to 1949, is evidence of this national genocidal purpose. Further proof of this purpose is found in the so-called curriculum of the residential schools, which was devoid of anything more than the rudimentaries of reading and writing, consisted overwhelmingly of religious indoctrination, and actively discouraged higher learning among Indians. The so-called schools were in practice an enormous dumbing-down regime set up to mentally subjugate Indians at a tender age and so contribute to the long-term destruction of Native societies. According to many former students, children in these schools spend much more time working as forced unpaid laborers in local fields and workshops or as domestic servants in Caucasian homes than in actual schooling. Principals like United Church clergyman George Raleigh in Mission, British Columbia, even rented out students under his care who were as young as 5 years old to work as unpaid farm laborers. Significantly, this double standard of what constituted education for Indians extended to all areas of life in the residential schools. Two separate standards of health and medical care existed in these facilities, as evident in letters from school doctors like Dr. Edward Pitts, who stated in 1934 that he was compelled to apply a different standard of care to Indian children than he would to white children. In other words, if he was to apply the same standard of health care to Indians, he wrote, he would be forced to recommend the immediate closure of every Indian school. According to statements of leading jurists at the Nuremberg tribunals, such a systemic double standard of care is one of the strongest indicators of a general plan to exterminate a group of people over time. In the case of Canadian Indian residential schools, statements like those of Dr. Pitts and senior civil servants reveal that the massive dying off of Indian children was perceived and treated as normal and acceptable by government and church leaders. This attitude of rationalizing and allowing genocidal death rates in the residential schools was even stated explicitly by the highest government official responsible for Indian affairs, Duncan Campbell Scott, who in 1909 commented that, quote, "We must accept that in the course of our work, enormous numbers of Indian children will in fact die from tuberculosis. This cannot be avoided." The intentional nature of this genocidal purpose is evident on a broader scale by comparing the federal laws brought in during the same period that Indian schools were established by a secret order in council. As early as 1909, government medical officers like Dr. Peter Bryce of Ontario documented that over half the children were routinely dying in church-run residential schools from what Bryce called, quote, "diseases that are deliberately introduced by church staff," unquote, including smallpox and tuberculosis. Despite this knowledge, the government sanctioned full church control of these schools the following year in a contract ratified in November 1910 in Ottawa between government officers of the Treasury Board and Indian Affairs and representatives of the Roman Catholic, Anglican, Presbyterian, and Methodist churches, the latter two being the predecessors of the United Church of Canada. Similarly, as the death rate in the schools climbed from disease and starvation, the government, under church pressure, actually abolished all medical inspection of these schools in the spring of 1919, on the very eve of the legal compulsion of attendance in these schools in the year 1920. No explanation has ever been given why medical inspection of chronically disease-ridden institutions and the infected and sick children within them was abolished, once again by a secret order in council. But during the subsequent decade, the massive death rate that continued among Indian children was actively concealed by new laws that denied Indians the right to hire lawyers or bring lawsuits in Canadian courts, and which in 1929 actually transferred the legal guardianship over residential school children to the clergyman principal who ran the school. During the same period, in 1928 and 1933, the first sexual sterilization laws aimed at Indians were passed by legislatures in British Columbia and Alberta, where most of the remaining unassimilated Indians were concentrated. Thousands of Native children and women were made sexually infertile under these laws for such offenses as speaking their own language, not attending Christian church services, having especially high marks in school, or simply for misbehaving. As numerous international courts of justice have ruled, legislation and practices designed to deliberately make a targeted group infertile are the clearest proof that a government is committing intentional genocide. The actions of Canada and its churches, which pushed for the passing of these sterilization laws and utilized them to sterilize Indians in special church hospitals geared for that purpose, clearly meet this criterion. By the late 1920s, sterilization clinics were concentrated on Canada's west coast and run mostly by United Church missionaries like Dr. George Darby, Sr. of the R.W. Large Hospital in Bella Bella. According to eyewitnesses, Darby made generations of Native families infertile by using such methods as tubal ligations, intrusive surgery, vasectomies, and prolonged exposure of Aboriginal genitalia to X-rays. Church of England doctors in northern Canada operated similar sterilization clinics aimed at the Inuit peoples, as eyewitnesses will describe. Remarkably, even with the revoking of Canadian sterilization laws during the 1970s, Aboriginal women are still often coerced into being made sterile by government health workers and welfare agencies, including through the use of so-called public health vaccinations and injections. It is important to note that the legal and legislative power to enforce such ongoing genocidal acts in Canada is guaranteed by the Indian Act of Canada, a federal law still in effect whose race-specific nature is outlawed under United Nations treaties and human rights protocols. This act defines Aboriginals living on state-funded reservations as non-citizens who are, quote, legal wards of the state in perpetuity, meaning forever. Such a reduction of men and women to the status of legal slavery is a clear violation of international law and is the means for genocide to continue. While considering this massive century-old mechanism to ensure ethnic cleansing across Canada, it's hardly surprising that residential school staff and clergy felt free to routinely rape, torture, and kill Native children, knowing they'd get away with it. Catholic priests at the St. Mary's School in British Columbia, for instance, described in letters written in their own handwriting in the year 1922 how they regularly dispatched children who were infected with smallpox at the school back into their own villages, with devastating results. Besides constituting a program of outright eugenics, Canada's Indian residential schools existed as well as lucrative child labor operations that hugely profited the churches that established and ran them, and which resisted their closure. These operations forced children as young as 5 years old to labor without pay for more than 12 hours a day. Residential school principals often received generous kickbacks from local white employers for renting out their young charges. As well, the same child slaves were the main labor force at the Indian residential schools themselves, helping to construct and repair buildings, milk cows, harvest the school crop, and do the staff's laundry. Children were routinely injured and killed in such duties, and their deaths were rarely reported. Besides receiving lucrative per capita federal grants for every child under their control, Catholic and Protestant churches were given by the Crown of England large swaths of land rich in timber, mineral, and marine resources upon which these residential schools were built. Usually, this land was sold off later by the same churches for huge profits, without any of the money going back to the native nations who had never approved of the theft of their land by these European churches. Now, this specific charge that the defendant churches profited in stolen Aboriginal lands and resources will be documented in detail by our office and constitutes solid proof that the key aspect of genocide by church and state in Canada, the theft of land and resources, was not only a cornerstone of life in Canada, but it continues to the present day. In particular, we will examine the case of the United Churches profiting in land stolen by their missionaries from the West Coast Ahousaht Nation, as brought to light at the cost of their livelihoods by Ahousaht elder Chief Earl McQuinna George and United Church minister Reverend Kevin Annett in 1994. It is now undeniable that these churches and their early missionaries actively cooperated and continue to work with private corporations to steal and profit from Aboriginal lands and resources. In fact, a basic purpose of the Indian residential schools was to facilitate this land grab by constructing the schools on rich resources, such as old-growth timberland and fishing grounds, especially on Canada's west coast. The first corporation into the Canadian West, the Royal Chartered Hudson's Bay Company, sponsored and paid for the earliest Protestant and Catholic missionaries into Indian Territory by 1820. Under a crown law known as the Clergy Reserve System, a Christian missionary was allowed to preempt any Aboriginal land simply by pitching his tent on it, and his church was then given hundreds of acres of the adjoining land and territory. Our office will introduce specific evidence of how these missionaries played an active role in wiping out entire Indian nations, occupying lands sought after by European companies, such as in the case of Church of England missionary John Sheepshanks, who in the year 1864 infected most of the Chilcotin Indians in central British Columbia with smallpox. Well over 90% of the Chilcotins then died from this introduced disease. Reverend Sheepshanks conducted this murderous operation under the direct orders of the Church of England, at the behest of the Puget Sound Land Company, a subsidiary of the Hudson's Bay Company, in which Sheepshanks, Anglican bishops, and colonial government officials were all shareholders. These men had illegally preempted the Chilcotin territory just prior to Sheepshanks' murderous inoculations, and thereby quickly came to own all of the land around the present city of Quesnel, British Columbia. Sheepshanks was subsequently rewarded by the British Crown for these deeds with a seat in the House of Lords and with a bishopric of Norwich. This pattern of church, government, and corporate collusion and genocide remains a permanent feature of Canadian society, evident in the continued devastation of Native communities by uranium, water, mining, and timber companies that access these lands through financial agreements with the churches that originally seized these Aboriginal territories. This systemic crime highlights a crucial aspect of the work of our prosecutor's office, which is namely to avoid the trap of particularism, that is, of focusing on individual aspects or perpetrators of these crimes, and thereby missing the bigger pattern and purpose behind them, and the institutions and their chief officers that ordered the crimes. The court must consider at all times this wider purpose at work behind the facade of Indian residential schools and the crimes we will document, and how that purpose continues to operate today in Canada with full legal and moral sanction. The secretive and hierarchical power structure within Indian residential schools was designed to conceal from the beginning this overarching genocidal purpose and the nature and extent of the crimes committed within them. While under the direct authority of both the federal government, which co-funded them, and individual churches, which appointed their staff and administered and paid them, the residential schools functioned under the daily rule of a single man, the principal clergyman, who was the sole legal guardian of every child inmate thanks to a federal law embodied in a standard document introduced in 1929 known as the Application for Admission Form. The principal had absolute authority over every child and employee in the residential school. Under rules and regulations still in written force in the year 1962, the principal could fire on the spot any employee who spoke to reporters or outsiders without his permission, who challenged his decisions, or who refused to carry out his orders no matter how heinous they were. All letters by staff as well as students were personally censored by the principal, and local police had no authority to inspect Indian residential schools or conduct investigations in them, even when injuries and death of children occurred on their premises. Clearly, this repressive military system operated outside the laws of Canada when needed, and was designed to not only effectively imprison children, but to control information and conceal criminal actions, especially since the churches operated them as secret centers that were laws unto themselves. Obviously, the churches had much to hide. As Dr. Peter Bryce himself stated in his October 1909 report, in which he documented how the deaths of Indian children were being regularly concealed and school records falsified by staff members to hide the enormous death rates. And that's a direct quote from Dr. Bryce. The deaths of children were, quote, being regularly concealed and school records falsified by staff members to hide these enormous death rates. And yet the lethal nature of these facilities was not unfamiliar to the government at that time, for these facts had also been officially reported within a few years of the school's opening, 2 decades before Peter Bryce's report in the year 1891. In a report by Federal Health Officer Dr. George Orton, the latter reported to the government, like Dr. Peter Bryce would years later, that rampant tuberculosis among Indian children in the schools was causing massive deaths as much as 50% of the students, and that these deaths were being actively tolerated by the staff. That's his expression, actively tolerated. Now, this is very significant and relevant to the whole issue of criminal intent, that such an enormous mortality rate among Indian children did not gradually develop, but was present from the very inception of the Indian residential school system. The fact that this mortality level of a constant 40 to 60% in the residential school system was continual for at least 60 years, from 1890 to at least 1950, indicates not the random acts of brutal employees or unavoidable problems caused by underfunding, which is what Canada and its churches still argue, but on the contrary, reflects a policy of extermination imposed and enforced at every level of Canadian society. The nature of deaths due to tuberculosis sheds more positive light on our claim that this illness was used as a deliberate germ warfare weapon by the churches and government. Because prior to the introduction of penicillin, infected individuals could only recover from tuberculosis by being quarantined, something never done among Indian students in these schools, where the sick and the healthy were regularly forced to work, sleep, and play together, according to letters and eyewitnesses we will cite. In order to die from this highly contagious disease, one had to undergo prolonged exposure to it under conditions that compromised one's immune system, such as the continually unheated, unfed, and stressful environment of the typical Indian residential school. Children didn't die quickly from tuberculosis once it was contracted. They had to be maintained in it over weeks and months without recourse to treatment or help in order for death to result from this disease. Well, so logically, for thousands of children to succumb routinely to tuberculosis, they're being kept in the conditions that spread it and ensured fatality from it was by definition an intentional action, and proves an intent by school staff and their bosses to commit genocide. For if such an intent was not present, why would the infected children not have been quarantined or moved elsewhere? It is also of importance to note that during the entire tenure of the residential school system, between 1890 and the closure of the last school in 1996, at no point did any level of government or any element within the operating churches act to close these Christian internment camps, even when the enormity of suffering and death within them was documented and well known and published in Canadian newspapers. Indeed, neither church nor state responded at all to the issue until they faced lawsuits by Aboriginal survivors early in the year 1996. Indeed, when Ottawa eventually began winding down Indian residential schools during the 1970s and 80s, it was the result of protests and pressure from Aboriginal nations themselves, and not because of an initiative by either church or state. And significantly, the power to reestablish Indian residential schools remains on the books in Canada and is still enshrined in the Indian Act of Canada. Let me summarize then by saying that the evidence of the criminal acts arising from the system of genocide, including the death and murder of Aboriginal children, is found not only in the depositions and statements of hundreds of eyewitnesses, and many of the ones we'll cite in this case, and the supporting documentation that will go along with those depositions. It is to be found as well in the physical remains of these victims at unmarked grave sites and burial cairns at 28 former Indian residential schools across Canada that have been surveyed by groups attached to this court. These sites have been identified and are presently the subject of an intensive forensic inquiry by our office to recover DNA and other remains and evidence of the identity and cause of death attached to these remains. Some of this forensic evidence from several of such sites will be described by our office in the course of this trial. However, we must caution the court that the full recovery of the remains of the children who died in these internment camps is probably impossible, not only because of the enormous number of deaths and the deliberate destruction of these remains by the Royal Canadian Mounted Police, the government, and church employees over the number of years. For the children who died at residential schools were often incinerated in the furnace of these facilities by school staff and their ashes scattered, according to eyewitnesses we will cite. The fact that, according to the Canadian government itself, document destruction teams were dispatched from Ottawa during the 1960s to eliminate student registers, death records, and other incriminating evidence at these facilities is further proof that the guilty parties have done everything to literally keep the truth of their crimes buried and forgotten. So finally, let us be clear that an equally convincing proof of this Canadian genocide is found in the actual lives of the survivors of these internment camps and their offspring. The death rate among Indians in Canada is still generally 10 to 15 times the national average, and deaths due to tuberculosis, disease, or violence are 40 times or more higher. This is often because many of the symptoms of the residential school-induced dysfunction are passed on to the survivors' children and grandchildren in a form of unrelenting intergenerational trauma. And yet, as people still restrained legally from full citizenship under Canadian law, Indians cannot recover in any real sense from the numerically worst genocide in human history. All of this is the basis of our argument that Canada, the Crown, the Vatican, and the Catholic, Anglican, and United Churches in Canada are equally culpable and guilty of ongoing crimes against humanity and their cover-up, and are all deserving of the strongest sentencing regarding these crimes. Our prosecutor's office will proceed now to display and explain the hard evidence of our argument and these crimes in the form of documents, eyewitness statements and affidavits, videotaped evidence, forensic evidence, and remains, and other proof submitted for the consideration of the court, its citizen jurors, in the entire world. I thank you. May it please the court. We begin the presentation of docket case number 0915.12.001 in the matter of the people versus the named fiduciary officers, members, and heads of state of the Crown of England, the Vatican, the Government of Canada, the United Church of Canada, the Roman Catholic Church in Canada and its papal nuncio, the Anglican Church in Canada, the Assembly of First Nations, Weyerhaeuser Limited, the Royal Canadian Mounted Police, and the Law Society of British Columbia. The prosecution claims and will prove beyond any reasonable doubt that the named defendants, either individually or as the responsible officers of the vicariously liable organizations, committed, colluded in, and are actively concealing any and all of the following 5 acts, which are defined as genocide under international law, as part of the regime known as Indian residential schools and hospitals across Canada. 1. Causing deaths, directly, indirectly, or by omission of action. 2. Preventing births or conception among the targeted group. 3. Inflicting bodily, mental, and emotional harm. 4. Creating conditions to cause the long-term destruction of the targeted group, including by forcing them off their land and stripping them of their livelihood, resources, and identity. And 5. Forcibly dislocating and relocating individuals from one group to another. The prosecution will prove, in the second case in the docket, that the defendants are engaged in an ongoing criminal conspiracy to conceal these facts and their guilt. Let us say as well that the complete archive of sworn testimonies and other documentation cited in this case is posted online for public viewing at www.hiddennolonger.com, although the material presented by the court today will include more material that's in that particular website. Now, to begin by providing a general picture of what we're presenting, our first exhibit, docket item number 1, is a summary of the documented offenses committed within these institutions and the facilities where the offenses occurred. 34 documented offenses are listed involving outright murder, torture, rape, slave labor, routine starvation and violence, deliberate exposure to communicable diseases, sexual sterilization, involuntary medical experimentation, child trafficking, kidnapping, obstruction of justice, destruction of evidence, and conducting a war of extermination on other nations. These offenses are attested to by a total of 278 witnesses who were former internees in 32 separate Indian residential schools across Canada. 15 of these facilities were operated by the Roman Catholic Church, 11 by the United Church of Canada, and 6 by the Anglican Church of England. In addition, the eyewitnesses also include survivors of 11 Indian or general hospitals. The documented offenses occurred between the years 1932 and 1981. Exactly what agencies were responsible for these crimes is attested to by our second and third exhibits. Exhibit number 2 shows that the Crown of England established the Indian residential school system in 1920 in a federal law created through Order in Council and then assented to in the House of Commons on July 1st, 1920. Exhibit number 3 shows that the residential schools operated under the joint authority of the Government of Canada and the various churches which appointed the principal. It should be noted that it was this document, published by Kevin Annett in 1996 and used in the first lawsuit of residential school survivors, that convinced the British Columbia Supreme Court to rule in 1998 that both the United Church and Government of Canada were jointly liable, and let me emphasize that, jointly liable for damages suffered by Indian children in the residential schools. That is, the legal and moral responsibility for all of the crimes committed in the Indian residential school system clearly and undeniably lies with both the churches and the Government of Canada, and the authorizing head agency known as the Crown of England. We will proceed now by presenting our evidence according to the 5 mentioned crimes, beginning with the category of homicide and manslaughter, the causing of deaths of children and others within Indian residential schools and Indian hospitals, either by deliberate murder, indirect killings, exposure to disease, or denial of care. The death rate within Indian residential schools in Canada was enormous and constant, averaging between 40% and 60% between at least 1891, when the schools commenced formally, and 1949, when Indian Affairs Superintendent Neil Parker commented that nearly half of residential school students were not surviving the system. Exhibit numbers 4, 5, and 6 are annotated records of the mortality rate in Western residential schools in the year 1909, taken from an earlier 1907 report by Dr. Peter Bryce of the Ontario Health Commission, who was dispatched by the Indian Affairs Department on a tour of all the residential schools in both the years 1907 and 1909. You will note that the documented death rates in these Indian schools averaged between 25% at the High River Alberta School, to 40% at the Pagan Catholic School, to 50% at the Blood Anglican School. The general level was 33% for all Alberta industrial schools, 1 in every 3 children, a rate comparable to the annual death rate at the Auschwitz death camp. This enormous death rate was made known publicly soon after Dr. Bryce's first report in a front-page headline article in one of the largest newspapers in Canada, the Ottawa Citizen newspaper, dated November 15, 1907, as displayed in Exhibit number 7. This article states, quote, "In one school, 69% of ex-pupils are dead, and almost everywhere the almost invariable cause of death given is tuberculosis," unquote. The practice of deliberately exposing healthy Indian children to those dying from tuberculosis is elaborated in Dr. Peter Bryce's short book entitled A National Crime, published in 1920, and displayed in Exhibit number 8. Bryce claims that as many as 75% of the students at the File Hill School in Alberta had died from tuberculosis, and that children infected with the disease were admitted en masse into the schools. Let me just state that this is a clear violation of the contractual obligations between the churches and the government. That contract document will be presented later on as part of our evidence. In Exhibit number 8, Dr. Peter Bryce also states that Duncan Campbell Scott, Deputy Superintendent for Indian Affairs in Canada, actually suppressed his report and refused to act on his recommendations. Independent confirmation of the average 50% death rate in the Indian schools is provided in a police report from the year 1922, issued by Corporal R.W. Clearwater of the Royal Canadian Mounted Police Detachment in Ocean Falls, British Columbia, and it concerned an Indian school home on the Kitimat Indian Reserve. In Exhibit number 9, Corporal Clearwater states, quote, "Since the home started, 49 had died and 50 were still alive." And that's in Exhibit number 9. The practice of housing the sick with the healthy that caused so many deaths continued throughout the history of the Indian residential schools, as eyewitnesses described. Video exhibits numbers 10, 11, and 12 are statements by Del Riley, incarcerated at the Mohawk Institute Anglican School in the 1950s, Delmar Johnny, an inmate at Cooper Island Catholic School during the 1950s, Virginia Baptiste of the St. Eugene School in the 1960s, and William Coombs interned at St. Mary's Catholic School in the mid-1960s. All of them, at opposite ends of Canada, were made to sleep or play with children sick with tuberculosis.
My name is Del Riley. I'm a member of the Chippewa of the Thames, and I spent 5 years in the Canadian government calls it residential schools, but really these were prisoner of war camps. I was in the one called the Mohawk Institute. When I originally came in, I had just gotten out of a sanatorium. Both my sister and I, we were admitted into here, and I just read her intake admission slip there. It said she had TB. Well, I must have had it. I had the same that she had because we were in the sanatorium together. My mother died there, and then they brought us here. So I don't know if we were used to infect people or not. I wouldn't know.
But you had tuberculosis when they admitted you to the mush hole, the residential school?
I couldn't guarantee that 100%, but I would have to say yes. Because nobody was there to examine, but this was common practice at these residential schools where they brought in kids that were diseased. There was no say filtration system within the school to properly circulate air or anything. So if one kid got sick, they all got sick.
Yeah.
In the same room with people who had TB, they didn't separate us.
Then we were forced to play with them. The nuns made us play with those kids. We didn't want to get sick either, but they were forcing us to play with those kids. And also, they made some of them sleep with the other kids.
Many children that weren't cooperative, like myself, wasn't cooperative, and they were put into with the children who were sick was at the end of the dormitory. They kept the sickies there, the ones who were sick with tuberculosis, and they put me and my brother Ernie in with the ones who were sick because we wouldn't comply.
This practice is exhibited in exhibit number 14, which is from the Sarcee Anglican India School in Alberta in 1912. You'll note the picture clearly shows that children with open tuberculous sores and head bandages sit alongside healthy children in a school classroom. The same practice is also documented in letters over 5 different decades, contained in exhibits 15, 16, 17, and 18. In November 1919, a doctor at St. Mary's Catholic School in Mission, British Columbia, is accused of causing an outbreak of smallpox among local Indians by actually sending children sick with the disease home from the school. Five years later, in 1924, the official record of discharged students at the Catholic Squamish School in Vancouver states that a young girl named Muriel Peters, quote, had TB germs when admitted to the school, unquote. And that's contained in exhibit 17. "13 years after that, in January 1937, a Dr. Pitts states that an Indian boy named Paul Shorty was admitted to the Catholic school with tuberculosis and, quote, has become a source of infection to the other children. The boy, quote, has never been cured of the tubercular infection with which he was admitted, unquote. And finally, in February 1952, an Indian named Bernard Johnson, who is being treated for tuberculosis at the Camsell Indian Hospital, is admitted to the Carcross Anglican School in the Yukon. Now, this specific practice of spreading deadly communicable diseases accounted for the high death rate among Indians generally, as the government's own statistics confirm. Exhibit number 19 from Canadian Census records shows a net decrease in the Aboriginal population of more than 20% across the country between 1901 and 1911, and another decrease during the 1930s. Let us add that while not trying to detract from these modern-day genocidal practices, the precedent of killing Indians with such germ warfare was established in Canada long before the time of the Indian residential schools, as Exhibit 20 clearly shows. This letter from British General Geoffrey Amherst, dated July 16, 1763, orders a subordinate to, quote, inoculate the Indians by means of blankets, to extirpate, that is to kill, the Micmac Indians in Nova Scotia using smallpox. So while generally germ warfare was a chief tool and cause for the high death rate in Indian residential schools, the deaths in these facilities were caused by many other factors too, including outright physical murder. The first eyewitness to describe the killing of a child in a residential school was Harriet Nahani, a former inmate at the United Church Residential School in Port Alberni. In 1995, Harriet describes the murder of 14-year-old Maisie Shaw by school principal Reverend Alfred Caldwell on Christmas Eve 1946, as video exhibit number 21 reveals.
So I watched, and she was standing at the top of the stairs, and he kicked her. She went rolling downstairs. She ended up, she was laying like this. Her eyes were open, but she wasn't moving. She wasn't crying. So I see that all the time.
Now, Harriet's story was reported in the Vancouver Sun newspaper in December 1995, the first such report of a murder of a child at a residential school in Canadian history, as Exhibit 22 indicates. A few days later, another eyewitness came forward to report the killing of a second child, Albert Gray, by the same principal, Alfred Caldwell, in 1938 at the United Church School in Ahousaht, British Columbia. As Exhibit 23 indicates, 12-year-old Albert Gray was beaten to death by Caldwell for taking a prune out of a jar, according to eyewitness Archie Frank. Caldwell never stood trial for either of these two murders, partly because the government concealed the crime. Now, this alleged death record for Maisie Shaw, found in Exhibit 24, Maisie Shaw, of course, being the child killed by Caldwell in 1946, this supposed death record was only entered into the vital statistics records of British Columbia in the year 1995, when her death was first publicly reported. The supposed death record claims that Maisie died of heart failure and was buried only 2 days after her death on Christmas Eve 1946, something never done, according to the British Columbia Coroner's Office. Nor did the Stevens Funeral Home in Port Alberni or the Seychet Cemetery, both listed on the death record, have any record for a Maisie Shaw. In July of 2008, Irene Fable described on national Canadian television how in the year 1944 she witnessed the incineration in a furnace of a newborn Indian baby by a Catholic priest at the Muskwagon Catholic Residential School in the province of Saskatchewan, as is exhibited in number 25.
Irene Fable, I'm 75. I went to a residential school in Muskogee in 1941 to 1949. And I had a very, very rough life. I was mistreated in every way. As a young girl, she was 7-year-old. She was pregnant. And what they did, she had her baby. They took the baby, wrapped it up in a nice pink outfit, took it downstairs. I was in the kitchen with the nun for cooking supper. They took the baby into the, where they make a fire and all that to heat up the school furnace room. They threw that little baby in there and burnt it alive. All you could hear was, that was it. And you could smell the flesh cooking.
Now, this practice of incinerating children's bodies happened not only in Catholic Indian residential schools in Saskatchewan, but in Alberta and British Columbia as well, as eyewitnesses Lillian Shirt and William Coombs describe in exhibits 25A and 25B.
What happened?
It was scary. Finding those little skulls in there. What were those little skulls? Where did they come from?
Could you describe what they looked like?
Tiny little ones. 2 little skulls. Tiny baby ones.
And they were in here.
I feel that fear we had running upstairs through that door.
Furnace burning 24/7, which was totally out of bounds, and me and a friend witnessed the sisters or brothers taking looked like little bodies under white wrappings or white cloth, and putting into the furnace.
Bill Seward told an audience in Vancouver in June 1998 how his sister Maggie died at the Catholic school at Cooper Island after being pushed out a window by a nun, in Exhibit 26.
Her name was Maggie. She was 2 years older than me. And she was murdered in there by a nun. She pushed out the window, second story up, and she died. But nothing was done about it. We weren't allowed to see a lawyer or nothing. They just covered this up.
And Harry Wilson and Dennis Tallio, both survivors of the United Church Indian School in Port Alberni, told reporters in 2005 how they discovered the dead bodies of children on the grounds of the Alberni School, in video exhibit number 27.
In '65, there's a bunch of us kids playing soccer in the back field. There was a brush of leaves and grass piled up, and there was a body underneath it. One of the kids kicked the ball and he went to get it. It was quite decomposed.
Went to Port Alberni in 1960, and I found a dead body in 1967 in between Ross Hall and Colwell Hall. Native girl, she was about 16, and I told Jay Andrews, and Jay Andrews shipped me out of Port Alberni, went to Nanaimo, and I believe it was a cover.
Sylvester Green and Doug Wilson, both former students at the United Church Indian School in Edmonton, described their participation in burial details at the school, where they helped to bury other Indian children. Video exhibits 28 and 29.
And I remember we used to go dig graves there, and they would be kids that came from Charles Camsell Indian Hospital. How they died, I don't know. But I know we just dug a lot of graves.
There was a lot of Eskimo babies
buried in that burial ground, which was behind the principal's house. Just on the other side of the staff garden. There was 4 of us that dug the grave. Myself, my brother Larry, Mel Patsy, and Albert Cardin.
And Ricky LaValle, who was held at the Catholic Indian School in Portage la Prairie, Manitoba, describes the gruesome torture and murder of his younger brother, who was 5 years old, at the hands of a Catholic priest. Exhibit 30.
My brother died because of a cattle prod, of a shock of a cattle prod. When he was 4 years old, they dragged him by the hair and they cut his skin right off his head. The pastors did that with a whip, like a horse whip. It was sharp, with these little blades on it. And when I was in there, I heard him scream for help. And right away, there was a lot of blood on the floor, and they wouldn't take him to a hospital or the nurse or nothing. What happened then? When I was in there, I heard him still scream for help. Rick, help! They're torturing me. I'm gonna die. So he died right away, like that. He was my only best friend and my only brother that I always loved.
And in the fourth case on our docket, we will examine in detail the murder of 9-year-old Victoria Stewart by United Church employee Ann Kaniski at the Edmonton Residential School in April 1958, as witnessed by Victoria's own sister. Exhibit 31. Across the country in Ontario, Lorna McNaughton, a survivor of the Anglican Indian School in Brantford, relates how her brother witnessed the mass killing of Mohawk children by Canadian soldiers near the Mohawk School in the year 1943. Video Exhibit 32.
Our dorm was just full of girls. And he said, yeah, so was ours full of boys. And he said, do you know what happened to them? And I said, no. And he said, they called in the army and they took them to the army base and they shot them. They stood them all along this big hole and they shot them, and as when the bullets hit them, they fell into the hole. And he said when they were all done, he said those that hadn't fallen into the hole, some of them were still alive. He said some of them were still alive in the hole. And he said they came along, and I want to say a bulldozer. That's what comes to my mind, but I'm not really sure that my brother had said a bulldozer. They came along with a big machine anyway, and they shoved them all in that big hole and they covered it up. And he says, that's what happened to them. And I must have been about 8, I guess, or 7 or 8, somewhere through there. Let's see, that must have been 43 or 44.
At the same residential school in Brantford, our office commenced the first independent excavation of an apparent mass grave of children who had died in the school in the October of 2011, at the invitation of local Mohawk elders. Video Exhibit 33.
Could you hold that up? So that's the sole of a shoe.
Yeah.
Bottom part. Looks like an old design, doesn't it?
Yeah, that's where it was attached to the boot. Very much. 7 and a half. No, we got it this way.
Just 6 inches down. It's definitely a piece of, we believe, human bone. There's the hip socket or a joint socket right there.
This excavation uncovered physical remains, including bits of bones and buttons that have been identified as coming from school uniforms from the 1950s. Exhibit 33A. Types of buttons, probably off of, well, clothing obviously, but the interesting thing is here at the glebe site, they're of the same style as if they're off a standard uniform or something. Could be a child's button off a school uniform. The significance of these buttons is that they were positively identified by Lorna McNaughton and another former student as coming from uniforms worn by girls at the Mohawk Institute Residential School during the 1950s. The fact that the buttons were found tangled in the roots of a tree 50 yards from the school building is that, according to McNaughton, whenever a child died in the school, the staff would plant a tree over their remains. Our office has identified 28 apparent mass grave sites at former Indian residential schools across Canada, based on eyewitnesses and ground-penetrating radar surveys. This list of grave sites was first released to the world media in April of 2008 and is contained in Exhibit 34. The reporting of deaths in the residential schools was continually covered up by local doctors, as is revealed in the standard report from one Dr. K.R. Blanchard at the Anglican St. George's School in Alert Bay in May 1948, concerning the death of a young student, Reggie Allen, Exhibit 35. You will note that the description of Reggie Allen's fractured skull is not accompanied by any description of what caused the fracture. Indian agents as well actively concealed wrongdoing in these schools, or events that may have caused embarrassment to the churches that ran them. Exhibit 36. This report from West Coast Indian agent P.B. Ashbridge, dated January 26, 1940, discusses the incineration of the United Church's housed residential school. Ashbridge writes, quote, "As this school was the property of and conducted by the church, care was taken to avoid too close inquiry," unquote. This act of collusion by the state to conceal wrongdoing and deaths was also expressed by an attitude that normalized genocide, generated from the very top of the government and church hierarchy. Exhibit 37, for example, is a letter from top Indian Affairs official Duncan Campbell Scott in the year 1910, who states, quote, "If the schools are to be conducted at all, we must face the fact that a large number of the pupils will suffer from tuberculosis. The admission indiscriminately of such pupils has no doubt led to the high death rate," unquote. This attitude of accepting the inevitability of sickness and death among Indians perhaps may account for the inexplicable abolition of all medical inspection of the Indian schools in the year 1919, at the very moment when deaths were climbing in these schools. Exhibit 38. Significantly, this annulling of medical supervision occurred just before attendance in the schools became mandatory under Canadian law in 1920, and occurred through a secret order in council. This suggests that the government was deliberately encouraging sickness and deaths in these schools. The fact is that the high mortality rate continued for so long because of a clear double standard when it came to health and medical care in Indian residential schools. In Exhibit 39, a school physician, Dr. Pitts, states in the year 1935 that he employs two standards of care, one for Indian children and another for whites, and that, quote, were I to apply the standards of health to them that is applied to children of white schools, then I should have to discharge 90% of them and there would be no school left, unquote. Furthermore, the government's official policy was not even to hospitalize Indians who were sick with tuberculosis, as evident in Exhibits 40 and 41, where that policy is quoted in letters from a residential school doctor in 1938 and a national newspaper in the year 1953. Now, why would it be the national policy in Canada for decades not to treat Indians contaminated with this deadly disease unless it was part of a plan to eradicate them? Now, the second genocidal act of which the defendants are guilty is imposing measures to prevent births and conception among Indians, both in the residential schools and in hospitals and communities. Laws allowing the involuntary sterilization of any industrial school inmate, which included the residential schools, were passed by the Alberta legislature in 1928 and the British Columbia government in the year 1933. The British Columbia law is displayed in Exhibit 42. Special Indian hospitals to sterilize non-Christian Aboriginals were established in Nanaimo, Vancouver, and Bella Bella, British Columbia. They operated from the 1920s until well into the 1970s. Exhibit 43. The R.W. Large United Church Hospital in Bella Bella was run by missionary Dr. George Darby, who, eyewitnesses described, sterilized Indian women for the slightest offense, as Ethel Wilson attests to in video exhibit number 44.
I couldn't have any more children after Dr. Darby got to me. He made an announcement in our village that anyone who wasn't in church on Sunday had to report to him for a special procedure. I never went to his United Church since they did so much harm. But Darby was missionary, so his word was law. So the Mounties came and got me and brought me to Darby. He gave me a shot. Next thing I knew, I was in bed, all bruised and hurting. I was missing all my gold teeth. Something didn't feel right inside me. I never could conceive after that. Later, another doctor told me I'd been sterilized. George Darby, he did that to hundreds of our women.
Other women suffered the same fate from Dr. Goodbrand in Duncan on Vancouver Island, like Sarah Modeste. Exhibit 45. Native men as well were sterilized in residential schools on Canada's west coast, exhibits 46 and 47. Now, in his book, War Against the Weak, America's Plan to Create a Master Race, the author Edwin Black states, quote, "In Canada, eugenics passions inflamed, and Alberta disproportionately sterilized Indians and Métis. Although just 2% of the population, they represented 25% of Alberta's sterilized." Exhibit 48 describes a 1999 class action lawsuit brought by Native women in Alberta against the government of Alberta for these sterilizations. Now, still today, Aboriginal women are being forced to be sterilized by welfare and government workers across Canada. Charlotte Stewart describes what happened to her in 1983 in Vancouver, in video exhibit 49.
My name is Charlotte Stewart. I'm from Kikatla, BC. I am Jimson Nation. I had a daughter 30 years ago whose name is Patricia, and she was apprehended. And after she was apprehended while she was a baby, I got pregnant when she was in the foster home. And the ministry found out I was pregnant, and they told me to have an abortion. And after I have the abortion, to have a tubal ligation, so I won't have any more children. They said if I didn't have a tubal ligation, then I would never see my daughter Patricia again.
Who told you that?
A social worker named Sally Heather. She was at the government office in North Vancouver. It was in the summertime. I can't remember what month. I think it was in July. And Patricia was born in 1982, so it would have been about 1983. She was about a year old.
And in 1979, the Canadian government and Catholic Church were forced to admit that its health workers were giving Inuit women birth control pills without their knowledge, telling them that they were vitamins. Exhibit 49A. Now, to quote this article from the Globe and Mail, quote, "A former official of the Indian Affairs Department who spent 2 years in Eskimo communities charged that there is an unofficial policy of recommending sterilization of Eskimo women after their 5th child. Dr. F.J. Colville confirmed that Eskimo women sometimes undergo sterilization after the 5th delivery. Catholic missionary Roland Courtemanche said, quote, 'You see, they need education. With more education, we will be able to control the population,' unquote. Now, this practice of targeted sterilizations against non-Christian Native people is long established across Canada among church missionary doctors. At the first independent tribunal into Canadian residential schools, held in Vancouver in June of 1998, a man from Waglisla named Ed Martin stated on record in June 13, 1998, quote, "I went to Dr. Darby in Bella Bella around 1952 to get a vasectomy because I couldn't feed the 10 kids I already had. But Darby just laughed at me and said, 'Ed, you're a good Christian. You need to have a lot of children. I only sterilize the pagans,' unquote. Then he told me he was getting $300 from the government for every pagan Indian woman he sterilized," unquote, and that's from Ed Martin's testimony of June 13th. His statement is on file with the International Human Rights Association of American Minorities, IRAM, a non-governmental organization with consultative status at the United Nations, which sponsored the June 1998 tribunal in Vancouver and even paid for the hall. The third genocidal act of which the defendants are guilty is the inflicting of bodily, mental, or emotional harm on Indian children. The Indian residential school system as a whole inflicted continual violence and harm on its internees, not randomly, but systematically. It was in fact established to do so by wrenching children from their homes, inflicting routine torture, rape, brutality, and terror on them as a matter of policy, and denying them their language, family, and identity. The guilt of the defendants lies in this general fact, and not merely in individual examples of it. We've noted already that the residential school system as a whole was set up to maintain Indian children in constantly unhealthy conditions, guaranteed by the abolition of all federal medical inspection of the schools at the very moment that the death rate was climbing, and when mandatory attendance into these schools was required by a federal law in the year 1920. But further evidence of the system for harboring Indians is found in that very same year in a statement made in the Canadian House of Commons by the Minister of the Interior, Arthur Meehan. In response to an opposition question about the massive death rates and epidemics raging among Western Indians, on June 8, 1920, Meehan said in the parliamentary record, quote, "The Health Department has no power to take over the matter of the health of Indians. That is not included in the act establishing the department. It was purposely left out of the act." And let me state that again. The quote from Arthur Meehan, "It was purposely left out of the act," unquote. Now, why would Indians be purposely left out of the laws governing the health of all Canadians unless they were not intended to receive proper health care? Leaving them out indicates a clear intent to allow them to die off, considering the widespread introduced diseases raging among the Indians at the time. This policy, confirmed by the Minister of the Interior and openly debated in the Parliament of Canada, constituted a deliberate collective act of violence aimed at every Aboriginal man, woman, and child in Canada, and legitimated and facilitated that violence in the residential schools. Since the system as a whole was geared to such brutality against all Indians, individual examples of assaults on the bodies, minds, and spirits of children in these schools are not ultimately the test of guilt facing the defendants. That is, the defendants need not have committed such individual acts themselves to be culpable for them, since they help to maintain and hide the effects of this system. Nevertheless, our office will present evidence of these individual acts of violence, such as the operation of an electric chair for torturing children at the Catholic St. Anne's Residential School in Fort Albany, Ontario, during the 1960s, Exhibit 52. Both Marianne Nakagi Davis and Edmund Matata-Wabin were victims of the Fort Albany electric chair at the ages of 8 and 6 years old. Survivors at the United Church Alberni Residential School, like Harry Wilson, describe a similar electric chair in the use in the school basement. Lorna McNaughton was also subjected to electric shocks at the Anglican Mohawk Institute in Brantford. Video Exhibit 53.
So it must have been about 39, 40. And from that time till the minister left, Mr. Snell left, we used to have shock treatments. And the senior room teacher, Mr. Yendel, used to put this little girl's hand on a plate or on something, and she'd get a shock. We'd all join hands. And she'd get a shock, and then it would pass from girl to girl, all the way around the room. And we did that probably every 2 weeks, around maybe twice a month. It was quite often anyway.
Virginia Baptiste tells of the use of electric shocks on her younger brother at the Catholic St. Eugene Residential School in Cranbrook, British Columbia. Exhibit 54.
He used it on my brother's penis. He electrocuted his penis there till my brother passed out. And he was laughing, brother. My brother said he was laughing while he was doing it. We'd like to see him in pain.
And Kenny Quatel, at the age of 6, was subjected to similar tortures at the Nanaimo Indian Hospital on Vancouver Island, Exhibit 55.
Had put needles in my head and had hooked him up electrically and would zap me. At that time, my arms were put in a chair and locked in so I couldn't move. And my head was put on a brace in the back so I could not, I was like this, I couldn't move. And I can't tell you how long they had done it. All I remember is that I still, to this day, I still get a, you know, like my brain will still have that kind of a kick from it, right?
Right.
And they had done a lot of bad things by putting medications in the food while I was in the dark room, bringing the food in, and you had to eat it, and if you didn't eat it, then if you threw it up into a bag, they put it on a plate again and make you eat it.
Another form of routine torture was the denial of painkiller to residential school children, where the teeth were filled or extracted by government or church dentists. A common practice in both the schools and the Indian reservations, according to Aaliyah Point, Exhibit 56. And Dennis Telio described the same torture he experienced at the Alberni Residential School in a statement made in October 1997, Exhibit 57. I want to read from that exhibit. Quote, "It's true that the dentist never gave us painkillers when he worked on our teeth. He'd even drill on us, right on the nerve. He liked to jab my gums all the time, prick me badly if I moved at all when he was working on me," unquote. And now the same torture of denying painkiller to Indians was not occasional but actually spanned many decades and operated systematically, as these two documents from 1924 indicate in Exhibits 58 and 58A. This is an official report from the dentist for the Catholic St. Paul Indian School in Vancouver. It's dated May 1924, and it shows that there were two categories of children he operated on: those who received local anesthetic for teeth extractions and fillings, and those who didn't. In other words, this official practice of torture on children occurred in Indian residential schools for at least 40 years. This denial of proper dental care to residential school children was officially exposed in April 2000 in the Canadian media, Exhibit 59. During the 1940s and 50s, the Federal Health Department denied vitamins and dental care to children in residential schools across Canada to study the effect of vitamin deficiency and gum decay. This chronic disregard of Native children's health was addressed in January 1946 in a formal petition to the government from 40 tribal chiefs in northern British Columbia. And it states that at the Lejac Catholic School, sick children were never separated from the healthy, and children were not allowed indoors when the weather was cold. Exhibit number 60. There is no record in the same Indian Affairs file of any reply from the government to this petition. But letters from Indian agents continually confirmed what the Native elders were claiming, that conditions in residential schools were continually harming children and threatened their lives. As early as 1896, top Indian Affairs officials recognized that, quote, Many children apparently healthy on their admission to the different schools are afflicted with tuberculosis, unquote. And that's contained in Exhibit 61. Even more revealing is the statement by W.J. Chisholm, inspector of the Indian schools, in September 1905, when he states, quote, "Whatever good the children may receive through residence in boarding school will be at the expense of the health of all and the lives of some," unquote. And let me emphasize that, at the expense of the health of all and the lives of some. Exhibit 62. He seems to be stating that the health of children inevitably will suffer, as a matter of fact, while entering the residential school. Nevertheless, these official warnings were ignored, for the same unhealthy conditions facing all of the children continued throughout the 20th century. Exhibit 63. This letter from the principal at the United Church of Houses School in January 1929 describes the school water supply as a menace to health, refers to the damp and unheated building a non-functioning toilet system, concluding, quote, "It is not to be wondered at that there has been in recent years a very unusual number of deaths and discharges from school due to physical ailments, nor that at the present time the proportion of thoroughly healthy children in the school is alarmingly low," unquote. Yet, a decade later, exactly the same unhealthy conditions were prevailing at the same housed residential school, according to Indian agent P.D. Ashbridge, who wrote in June 1938, quote, "This building can only be described as a fire trap and a menace to health. Sanitary arrangements are terrible," unquote. Exhibit 64. Now, why was the United Church allowed to cause such documented harm to Indian children under their legal care and never be compelled to improve health conditions? As Indian agent Ashbridge himself commented in the 1940 letter referred to in Exhibit 36, quote, "Care was taken to avoid too close an inquiry," unquote, about anything involving the residential schools. In other words, an act of tolerating by the government of murderous practices by the United Church in this case. This kind of arrangement is only possible when every level of a system is authorized to cause harm or neglect and is never to be held accountable for it. The churches and the residential school staffs knew that they could kill Indian children directly or indirectly and get away with it. More proof of this is found in this letter from a principal at the Anglican St. George's Indian School in Lytton, British Columbia, in June of 1942. Exhibit 65. In it, C.F. Hives had enclosed a set of chain manacles in his letter to an Indian Affairs official in Ottawa. Describing the headmaster who preceded him, Hives states, quote, "Two girls ran away, and they were chained together and driven home in front of the principal. They used the shackles to chain runaways to the bed. They also had stocks in the playground, and they were used," unquote. Many survivors, describe the prescribed leather strap, and that's, quote, "prescribed leather strap," that all residential school staff members carried on their belts to enforce daily random beatings. In the words of Elmer Azak, which is contained in Exhibit 66, which I'll quote from, Elmer Azak, a Tsimshian Indian who survived the United Church Alberni School between 1967 and 69, quote, "My whole life has been destroyed because of that school. We were strapped every morning, even if we did nothing wrong. Everybody got the strap automatically. Everyone on staff carried a strap. I was constantly scared. Kids always disappeared from there. John Andrews, the principal, he knew all about it. But I never saw an Indian agent the whole 3 years I was in Alberni. The government just ignored us, let the church do whatever the fuck they wanted to us. I haven't been able to have a normal sex life since I got raped so much there. I wish it had been burned to the ground." Unquote. Now, a big part of this terror was not only daily beatings, but systematic rape, which was the norm at the average Indian residential school. As Edmonton school survivor Sylvester Green recalls in video exhibit 67,
"Took each of us in there one by one, and he had us bend over and he had Vaseline with him. He did that to each of us 3 times, I remember that. To satisfy himself, to enjoy himself on little kids. I forgot how old I was, either 6, 7, or 8, maybe 9, I forget. But I remember, I'll never forget Mr. Moore.
in Exhibit 69, a letter from February 1937, Indian agent F. Ball describes how at the Catholic Seashell School near Vancouver, one boy, quote, who died of tuberculosis was punished a month or so before he died by being forced to hop on one leg up and down the schoolyard in spite of his protest that he was in pain. The father of the boy said he had been told that the boy was seen at the school window calling for him and was slapped for it the day before he died. Unquote. Behind the routine rape and torture was a constant aim of terrorizing and degrading Indian children, often resulting in their deaths. Former RCMP officer George Brown describes his friend's experience of being flogged at a Catholic Indian residential school in British Columbia in Exhibit 68.
He was punished in a residential school where he had 60 lashes on his back from a strap. And he said, "You're probably wondering how I know that, George." He said, "Because the kids had to count out the lashes on his back." And he said, "You thought that was bad." He said, "My buddy got it 300 times. And he said, the only reason why the sister had quit, he said, is because she was too tired. She couldn't wail anymore." And 2 weeks later, that young boy died.
Psychological terror was constantly used on children, as Catholic Cooper Island School survivor Belvie Brever describes how children were made to watch the body of her dead brother who was hanging and who were threatened in video exhibit 70.
"You know what, sis?" He says, "I can't wait to get out of this hellhole. I'm going to tell everything." And then the phone went dead. People at Cooper Island always listened to our phone calls and censored our letters back, coming in and going out. So I was afraid for him, but I didn't think it was going to be as bad as it was. It turned out as bad as it was. 2 days later, we got a phone call saying that he hung himself. He committed suicide. But I'd never, ever believed in my heart that he'd ever do that. They had them walk through the gym while Richard was still hanging and told them that it could happen to them.
The same method was used in another Catholic Indian school in Vancouver just a few years later, in 1966, video exhibit 71. The regime of residential school violence is best summarized by Native leader Del Riley of the Chippewa Nation, who survived the Church of England school in Brantford. Video Exhibit 72.
Probably from being every one of the 6-year-olds I was in here was sexually abused, and myself as well, multiple times, multiple, and double-digit figures of every one of them. It happened to all of us, and they starved us, beat us, froze us, and it was horrific. There was no controls in the place. Kids were always getting beat up or being put through various torture rituals, such as first got here we had to go through they call one of those where everybody beats on you. Just forget what it's called.
Running the gauntlet?
Gauntlet, yeah, we had to run the gauntlet. We were beaten severely for the most minor infractions. They try to instill absolute fear into you.
Yeah.
And I guess the crazy thing was, I don't know how all those kids survived the way they did, but they were all hungry. We did whatever we could to try to supplement our diets, from stealing raw vegetables, eating raw vegetables, eating frozen apples, digging in the garbage. Once a week we would be able to go and dig in the garbage and supplement our diets, but that was the way it was done.
Now let me summarize this first section by stating that in none of the 278 testimonies of residential school survivors in Canada that form part of the basis of our evidence did any of these survivors describe not experiencing some form of deliberate brutality and violence. Here are the raw statistics of their experience. 100% of them experienced forcible confinement. 100% of these witnesses experienced having their heads forcibly shaved. 100% of them were forcibly denied the right to speak their own language. 100% of them were denied proper or regular food. 100% of them were denied adequate education. 97% of them, 271 out of 278 witnesses, were beaten in some form. 95% of them, 265 out of 278 of them, were psychologically tortured or intimidated. 90% of them, 253 out of 278, were forced to engage in unpaid labor. 89% of them, 251 out of 278, were denied adequate heating and clothing in the dorms. 67% of them, 183 out of 278, were raped or sexually molested. That's 2/3. 56% of them, 161 out of 278 of them, were forced to watch or participate in the beating or torture of others. 54% of them, 156 out of 278 of them, were physically tortured in some way, such as electric shocks, needles stuck through their tongue, teeth pulled out without anesthesia, chicken wire wrapped around boys' penises, and those kinds of things. 54%, over half. 43% of them, 129 out of 278 of them, were used in involuntary drug testing or medical experiments. 17% of them, 45 out of 278, experienced forced abortion or involuntary sterilizations. And 33 out of 278 of them, 12% of them, were participated in actually burying other children who had died or been killed in the residential schools where they were incarcerated. Now, a complete list of all of these documented tortures and assaults is provided in Exhibit Number 1. May it please this court, this summarizes the prosecution's argument in the first 3 of the 5 sections of our first case in the docket. Our next presentation will address the latter 2 crimes in the indictment and will be presented approximately around November 15th. We conclude this first section with this list of the names and cause of death of 40 children who died in Indian residential schools and 10 Native men and women survivors who have died under questionable circumstances while working with our campaign.